are to receive a response to that stipulation. He did write a letter to the court in response to that stipulation. And the court then, Your Honor, responded and stated to Mr. Mulligan to order a transcript from the hearing. And I'm still waiting to receive that transcript. I have gotten some other communication from Mr. Mulligan stating that Ms. Hawkinson wanted to arrange to have a contractor to come out to the property. I requested on September 25th, 2024, for 3 available times that the contractor would be able to come onto the property. I have yet to receive a response to that. So at this point, Your Honor, we are waiting for information from Mr. Mulligan.
Mr. Mulligan, please provide me an update and let me know why I shouldn't just dismiss the matter with prejudice, which is my original decision in this matter, and leave it at that, because I'm going to tell you, I'm getting the runaround and it's frustrating the court. It's making a mockery of the judicial system. It's causing an extensive and substantial amount of financial legal responsibility, not only for your client, but for the wolves as well.
Buckle up, guys. Today we're diving into a courtroom standoff that spirals out of control fast. From the moment Judge Simpson takes the bench, you can feel the frustration boiling. She's fed up with the delays, the excuses, and the disrespect for due process. The way she calls it a mockery of the judicial system, that's your warning. This won't be your average hearing. She's not here to play games, and this room is about to feel that.
Why should the court not deny the motion for reconsideration and go back to it and have its original decision stand? Because again, July 25th, in which the court had all parties here to hear a motion for reconsideration. The parties were given an opportunity to sit down and to have time to reach a settlement, which they apparently did. The court was prepared to make a decision that day on whether or not to continue with the motion for reconsideration or to continue with its original decision, which was to dismiss the matter with prejudice. Mr. Mulligan, please entertain the court and give me some information.
Well, number one, Your Honor, the stipulation in order was not in conjunction
Mr. Mulligan, 807.05 Wisconsin statutes. It was stated on the record, Wisconsin statute 807.05 makes it binding. And at that hearing, the court said, and I quote, it said, "Whoa," and were stated on the record, and it shall be so.
The record shows that we reserved our position once the opposing parties have ascertained any additional information. We reserved
Mr. Mulligan, I'm stopping you right now. I don't want you to reserve anything right now. I want you to tell me why I shouldn't go back and keep my original decision to dismiss, because we're still on this reconsideration. Dismiss with prejudice. That's where we were. And when we were here on July 25th, I gave the parties the opportunity to try and resolve the matter and stipulate to an agreement that could work for both of the parties, because I looked you in the eye, I looked your client in the eye, and both of you knew that your time to appeal had lapsed, that you had no longer an ability to appeal because there was no longer any time to appeal. Both you and Mr. Benson lost that by both other counsel. So I gave you an opportunity to reach an agreement in this matter. It was placed on the record. Tell me why I should not continue with my original decision to dismiss this matter with prejudice. Has this reached a decision? Am I to get the transcript, and am I to do an order based upon that agreement that was reached? Or is this matter dismissed with prejudice?
The judge doesn't let up. She zeroes in on Mulligan, demanding accountability over a transcript that should have been ordered long ago. She brings up past hearings, calls out inconsistencies, and applies intense pressure, daring him to give a straight answer. You can see him squirming under the weight of every missed deadline and broken commitment. What starts as probing questions quickly turns into a professional reckoning.
Tell me now, Mr. Mulligan. I don't want to hear any this, that, or the other, and my client wants more money, my client wants this, and my client wants to agree to that. I do not want to hear that, Mr. Mulligan.
That was made a part of the record, Your Honor, and I think it's important for...
Mr. Mulligan, I want the basis of an agreement. Is there an agreement and that the court can reach other, and the court, myself, me, the judge, can reach a decision on other issues, or is this matter dismissed with prejudice?
Well, it should not be dismissed with prejudice. We briefed that fully and would like a hearing.
No,
Issue.
no. July 25th, Mr. Mulligan, you had since July 25th. And prior to that, Mr. Mulligan, prior to that, you had a whole lot of other time. Prior to that, August 9th. Prior to that, Mr. Mulligan, you had September 26, 2022. Prior to that, Mr. Mulligan, you had September 27th, 2022. Prior to that, Mr. Mulligan, April 4th, 2022. I am losing my I'm losing my patience here. Losing my patience.
To opposing counsel in August in an effort to get this matter.
One question, Mr. Mulligan. One question, Mr. Mulligan. And you answer this question and you think very carefully. You think very carefully, Mr. Mulligan. September 18th, 2024. September 18th, 2024. On your letter written to the court, your letter, which the court received on September 18th, 2024.
Things hit a boiling point here. The judge delivers a devastating blow, walking through Mulligan's inaction, line by line. She pins him down with a direct question. Did you order the transcript? What follows is silence, dodging, and then the start of a total unravel. This is where his credibility begins to collapse in real time, and the judge isn't letting go. You can almost hear the gavel dropping before she even speaks again.
In which you asked about language brought up in court and the contents. This court, myself, the judge, wrote, Mr. Mulligan, please order a transcript so that the parties and the court can see what was actually stated on the record for the agreement. We cannot rely upon minutes. Judge Mogen, September 18th, 2024. And I'm asking you, Mr. Mulligan, right now, think extremely careful about your answer. And it is a yes or no question. Yes or no. Did you order that transcript after September 18th, 2024? Yes or no?
I've got the transcript, but I don't have a recollection of Your Honor mailing me a response.
It was filed, Mr. Mulligan, this is an electronic file. So you received it electronically on September 18th, 2024. If you have the transcript, then why isn't it in the file? Because the court reporter files it once she does it. Well, who is the court reporter? Look at the transcript right now. Tell me who is a court reporter.
I don't have that information.
Get the transcript right now. Tell me who is a court reporter.
I can't because I don't have that information. I've got a copy.
I don't think you ordered it.
Transcribed.
I'm going to contact the court reporter and I'm going to ensure that you ordered the transcript as the court ordered. If you did not order the transcript, I am holding you in contempt and I'm ordering sanctions. Did you order that transcript, Mr. Mulligan?
I don't believe I did.
You just lied to the court. You literally just lied to the court. This matter is dismissed with prejudice.
I don't lie.
This matter is dismissed with prejudice. You just lied to the court, Mr. Mulligan.
This is the moment the courtroom explodes. Mulligan tries to save face, claiming he has the transcript. Seconds later, he's forced to admit he never ordered it. The judge catches him in the lie immediately and cuts in. You literally just lied to the court. That's it. Case dismissed with prejudice. She also threatens contempt and sanctions. It's judicial fury at its rawest. This wasn't just a mistake. It was a straight-up courtroom ambush.
This matter is dismissed, Ms. Wolf, with prejudice and with costs.
Thank you, Your Honor. Would you like us to submit an affidavit of attorney's fees?
Yes, I will. and whether or not you wish, the court is holding Mr. Mulligan in contempt for his failure to be truthful with the court right now. He just stated he ordered that transcript when the court told him to order that transcript.
Well, wait a
And he
minute.
just stated, you literally just stated on the record,
Ordered the
Mr. Mulligan.
transcript.
You literally just
Said I
stated.
have a copy of the transcript. I did not lie to the court.
There, if you said you have a copy of the transcript, you can't have a copy unless you ordered it, because no one ordered it.
I
And you
have
were
a
told to
copy
order
of
it. How do you have a copy of the transcript?
I don't have an answer for that, but I was thinking it was the clerk's notes.
No, you have minutes. And that's what I said. In your letter, you said, if you want me to read your letter verbatim, the plaintiff agreed only to the language that was brought up in court as to the contents of a concrete walkway. None of the rest was brought up to the court. Also, the remaining slab will have to be supported some other way. We will abide by what was announced in court, not what was added to the agreement which is attached. We will follow the agreement as set forth in the agreement put on the transcript and not the extra verbiage, as it is beyond the scope of the agreement. Very truly yours, Thomas O. Mulligan. And you attached the minutes from the clerk. You did not attach the transcript. That is where this court, myself, wrote on your letter, Mr. Mulligan, my own handwriting wrote on your letter, and I quote, Mr. Mulligan, please order a transcript so the parties and the court can see what was actually stated on the record for the agreement. We cannot rely upon minutes. Judge Mogen, September 18th.
Now Mulligan tries to shift the narrative, suggesting clerk minutes were enough. But the judge isn't having it. She dismantles that argument fast, then reads his misleading letter back aloud. It's a brutal moment, not just exposing legal missteps, but an outright manipulation of court communication. This isn't a misunderstanding. It's damage control gone wrong. And just like that, his defense crumbles faster than he can backtrack.
2024. That was filed in the electronic file the same day and time, extremely right immediately after I wrote it on your letter, September 18th, 2024. Then Ms. Wolf sent correspondence not only to me, but to you, Mr. Mulligan. Dear Judge Mogen, I am in receipt of letter dated September 17, 2024 to the court from Thomas Mulligan, attorney for Carol Haskinson. The letter also includes your response to Mr. Mulligan dated September 18, 2024. It is my intent to respond to Mr. Mulligan's letter after Mr. Mulligan provides me with a copy of the transcript from the July 25th, 2024 hearing. Please let me know if you would prefer I respond at a different time or in a different manner. Respectfully submitted, Kelsey Law Office, PA Joanne Wolf. Ms. Wolf, did you then, after that letter was filed with the court, send a letter and have correspondence with Mr. Mulligan?
After sending that letter to the court, my assistant would have provided that to Mr. Mulligan, the letter. And then also there was communication with Mr. Mulligan on September 25th, 2024. I have an email from Mr. Mulligan to me with the name of a contractor. I believe it says, here's the information for the contractor, Construction Unlimited, and lists the phone number. And then I responded to Mr. Mulligan on September 25th, 2024.
Here, the judge puts together the final pieces. She walks through emails, transcript timelines, and shows Mulligan had every chance to act. But he chose delay over diligence. It's a surgical breakdown, and it seals his fate. The evidence is no longer just about documents. It's about deliberate stalling and disrespecting the court's time and authority. Every word from her bench sounds like a verdict before the verdict.
And I said, please let me know of at least 3 afternoons, evenings. This contractor is available so I can arrange it with the heads. And I never received a response from Mr. Mulligan since September 25th, 2024.
And the court has not received any receipt of anyone ordering the transcript from the court's order of September 18th, 2024. And Mr. Mulligan, in my correspondence to you, I indicated to you minutes are not a transcript. They cannot be relied upon as a transcript. You provided the court with minutes. Minutes are different than a transcript. Minutes cannot be relied upon like a transcript. The court informed you of that. The court ordered you to order the transcript from the court reporter. You now just said that you did so, and then now you said you didn't, or you have a copy of it. You do not have a copy of the transcript. This has been a complete waste of the court's time. My decision to have the matter dismissed with prejudice stands. Please draft the order, Ms. Wolf, and send it to the court to sign. Thank you.
This is the fallout. The judge confirms the dismissal with prejudice, then instructs the other attorney to draft the final order. She makes it crystal clear this wasn't just procedural failure. It was a fundamental disrespect for the court's process. Mulligan walks away with sanctions looming and reputation shattered. Justice wasn't just served, it was delivered with precision. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.